You've heard it a million times, right? In pretty much every cop show or movie, the Miranda warning. It feels like we all know it by heart. But what if I told you the real story behind those famous words is way more complicated and honestly way more interesting than Hollywood lets on?
Yep, those words. You have the right to remain silent. They're practically seared into our brains. It's that moment in the story where you know things just got real.
But where did this script even come from? And what's it really all about? See, behind that famous phrase is a huge ongoing struggle between a person's rights and the power of the police. And to get it, you gotta go back to the very beginning.
And believe it or not, this whole thing, this massive change to American law, it all started with one man. His name and his case would go down in history.
Meet Ernesto Miranda. It's 1963 and he gets picked up by police in Phoenix for some very serious crimes. But what happened next, inside that police station, is what changed everything.
So, the police question him for 2 hours straight. And by the end of it, Miranda signs a written confession. But here is the absolute kicker. The whole time, nobody ever told him he didn't have to talk. Nobody ever said, hey, you know you can ask for a lawyer, right? And that confession was pretty much the entire case against him.
Well, Miranda's lawyer appealed the conviction, arguing that the confession was basically forced out of him. In this case, Miranda v. Arizona, it went all the way up the ladder, right to the U.S. Supreme Court. The court had to tackle a huge question. What does the Fifth Amendment right not to incriminate yourself actually mean inside an interrogation room?
And get this, the decision was razor thin, 5-4. Just one vote tipped the scales, but that one vote completely changed the rules of the game for every police department in the country forever.
So what was the big idea? Well, Chief Justice Earl Warren, who wrote the decision, said that a police interrogation is, by its very nature, a pressure cooker. He called it inherently compelling pressures. Basically, when you're alone in a room with the police, you're going to feel pressured to talk, whether you're guilty or not. And that pressure, he argued, could completely crush your Fifth Amendment rights. To fight back against that pressure, the court came up with a solution, a script. They laid out these 4 specific warnings that police have to give. They're like a shield, designed to make sure that if you do confess, it's because you truly chose to. And boom, the Miranda warning was born.
But what about Ernesto Miranda himself? You might be wondering if he walked free. Well, not exactly. Because of the new rule, his first confession got thrown out. But the prosecutors took him back to trial. This time using other evidence, including testimony from his partner, and he was found guilty all over again.
Okay, now here's where it gets really tricky, and it's something that TV shows get wrong all the time. Cops don't actually have to read you your rights every time they talk to you, not even close. There's a very specific time and place for it. The magic phrase in the legal world is custodial interrogation. Let's break that down. Custodial means you are in custody. You're not free to just get up and leave. Think handcuffs or being in a locked room. And interrogation means they are actively asking you questions designed to get you to admit to a crime. You need both of those things for Miranda to kick in.
So, for example, when they're asking you your name and address at the station, that's just routine booking, no warning needed. If you just blurt out, "I did it," without them even asking, that's on you, and they can use it. And here's a wild one. If you confess to an undercover cop pretending to be your cellmate, well, you're out of luck.
But probably the single biggest exception, and the one that gets debated the most, is called the public safety exception. This gives police some major wiggle room when lives could be on the line.
So picture this. A cop chases a suspect down and arrests them in a crowded park. They have reason to believe the suspect ditched a gun somewhere nearby. In that situation, the officer can ask, "Where is the gun?" before reading the Miranda warning. The immediate need to find that weapon and keep people safe temporarily outweighs the warning requirement.
And let's bust one more huge TV myth. If an officer forgets to read the rights, it's not some magic get-out-of-jail-free card. It doesn't mean the whole case just gets tossed out. All it means is that the confession they got without the warning can't be used in court. If the prosecution has other evidence, just like they did with Ernesto Miranda, the case moves right along.
Now, you'd think that a huge Supreme Court ruling from 1966 would be the end of the story, right? Wrong. For over 50 years now, the courts have been tweaking, clarifying, and sometimes even weakening the Miranda rule. Its story is still being written.
We already talked about that public safety exception, which came about in 1984. Then, in 2000, the Supreme Court made a huge statement, saying that Miranda was a constitutional rule, which meant Congress couldn't just pass a law to get rid of it. But then, much more recently in 2022,
another big case came along that limited what happens when officers break that rule.
Yeah, that 2022 case, Vega versus Teco, is a real lightning rod. The court ruled that even if an officer fails to give you a Miranda warning, you can't sue that officer for money damages. Critics were outraged. They said this basically takes all the teeth out of the rule. What good is a right if there's no penalty for violating it? But supporters of the decision argued it was a good thing, protecting police from a flood of lawsuits for what could be an honest mistake in a high-pressure situation.
Okay, so we've been through the history, the drama, the exceptions, and all the legal battles. So what's the bottom line? What does all this mean for you? Right here, right now.
Let's boil it down. First, the Miranda warning is all about protecting your Fifth Amendment right not to be a witness against yourself. Second, remember it's not for every police encounter, only for custodial interrogation. Third, there are big exceptions, especially when public safety is at risk. And finally, this is not settled law. The debate over how powerful these rights should be is still very much alive.
Which kind of leaves us with one big question, doesn't it? The Miranda warning is one of the most famous legal concepts on the planet, a symbol of your rights. But when you look at all the exceptions and the recent rulings, it really makes you wonder, just how strong is that protection when you really need it?